trial and what is the policy behind trial. See, ultimately हमें दोनों parties के evidences को सुनना है and we have to arrive at a conclusion after appreciating those evidences. So we will be taking the evidences from both the sides and then finally जब हम एक conclusion पे पहुंचेंगे तब हम एक judgment deliver करेंगे. We'll pass a verdict. The major concern is that these giving of evidences and this leading of evidences and proving and disproving of facts, it has to be done in a fair manner and it has to be done in a detailed manner. There should not be any kind of miscarriage of justice. There should not be violation of natural justice between any proceedings, and we have to ensure that whenever a trial is being conducted, the court does not sit as a mute spectator, rather the court takes active participation in the dispensation of justice. That is why we have also provided a provision 168 BSA where court can ask any question to anybody at any time, relevant, irrelevant. Meaning to say what? That court should not be a mute spectator, rather court को एक active participant बनके proceedings के अंदर ध्यान रखना है that parties के rights को हम hamper ना करें. Great. Now you all know that there are certain cases which are exclusively triable by the Court of Session. These cases which are exclusively triable by the Court of Session, after all the proceedings are done, so you are into a case, you receive the charge sheet, after you examine the charge sheet, you go for cognizance, issue a process, supply of documents, after doing everything, you commit the case for trial under section 232 and you say that this case is exclusively triable by the Court of Session. When you send the case for trial to the Court of Session, what ultimately is going to happen is that the Court of Session receives for the first time the documents of the entire case. Because Court of Session is not aware about investigation, Court of Session does not receive occurrence report, Court of Session does not record confessions, Court of Session does not receive the police report first hand, Court of Session is not taking cognizance, not issuing process, not supplying documents. Court of Session has done nothing till. Probably a bail application might have gone to the Court of Session, but otherwise nothing. Moreover, the Court of Session is a court of trial primarily. That means the basic duty of the Court of Session is to conduct trial. And the Court of Session conducts the trial exclusively for those cases which have been mentioned, and these are all grave cases. So Court of Session has to be very, very careful in proceeding forward. Now, what happens is, when every document and every record of the case reaches the Court of Session, the Court of Session peruses the documents, goes through the documents, and the public prosecutor opens the case for the prosecution. That means it is the public prosecutor who is going to conduct the trial in a Court of Session. And this public prosecutor opens the case and tries to convince the Court of Session कि मेरे पास ये एविडेंस है, ये एविडेंस है, ये फैक्ट है, ये सीसीटीवी फुटेज है, ये कॉन्वर्सेशंस हैं, ये ईमेल्स हैं, नॉट इन डिटेल, जस्ट पासिंग रेफरेंस में the public prosecutor tries to convince the Court of Session that yes, I have a prima facie case against the accused. That means that when the public prosecutor opens the case and the Court of Session is examining the documents, hearing the arguments which are being led, the submission which is being made by the public prosecutor, the public prosecutor is trying to assert that yes, I have a prima facie case against the accused. That means in all probability this accused will get convicted and I am going to present these evidences in front of you. और उस एविडेंस को प्रेजेंट करने की जरूरत नहीं है, ना ही उस एविडेंस को डिटेल में डिस्कस करने की जरूरत है. इट इज जस्ट अबाउट mentioning those evidences. If you want to, out of 10 to 3 evidences you mentioned or 4 or 5 evidences you mentioned, and you try to basically create a picture in front of the court of session that, sir, in brief, this is what I am trying to explain. Like sometimes what I do with provisions, मैं आपको थोड़ा सा रोड मैप बनाता हूं और रोड मैप बनाने के बाद आपको प्रोविजन पढ़ा के उसको मैं समझाने की कोशिश करता हूं. उससे बेसिकली ये समझ आता है दैट इज प्रोविजन में बेसिकली स्टोरी है क्या, फिर मैं आपको डिटेल में लेकर जाता हूं. सो द पब्लिक प्रोसिक्यूटर ओपन्स द केस बिफोर द कोर्ट ऑफ सेशन. At the same time, the opposite party's advocate also tries to present his or her case that, see, the accused, my client, is not guilty at all, he is being framed, etc., etc. Basically, जो भी बोलना है in your defense, you try to sum up your feelings, you try to sum up your case in front of the court of session. That I'm proposing that the accused is not guilty and there is in no way that the prosecution can convict this accused. That is what the defense tries to do. So the prosecution tries to establish a prima facie case against the accused, and the defense tries to say that there is no prima facie case existing against the accused. Now, after listening to all these arguments, after hearing the submissions which have been made, there comes a time where the court of session has to decide whether the accused has to be discharged or whether I should proceed with the framing of charge. So the court of session then decides that should I discharge the accused or not. Now this is a very big step. Why? Discharge the accused basically here means that if the court of session, since it is a very grave offense because it is exclusively triable by the court of session, since it is a very grave offense, the court of session at the initial stages of the trial proceedings, it tries to ascertain whether there is a prima facie case made out against the accused or not. And that prima facie case will come from the public prosecutor opening the case for the prosecution and from the court of session examining the documents and material. So the court of session tries to decide that whether this particular accused will be discharged or not. If the accused, according to the court of session, is prima facie not guilty, that means no prima facie case is available against the accused. So you read the documents, you see, अरे यार मतलब I don't think so the accused is guilty here because clearly there is an established alibi. Why is he being prosecuted unnecessarily? So you will hear the public prosecutor, you will hear the defense on the opening arguments, and you will refer the documents, you will see what all evidence is placed on record. After you are through and thorough with the entire set of evidences and facts and the documents presented, not led, just presented before you, you will have to decide whether there is a prima facie case made out against the accused or not. That means, is there a heavy burden or there is a lighter burden? Is there a heavy burden or a lighter burden? On the prosecution? Heavy. It is a very, very heavy burden on the prosecution to establish that yes, a prima facie case is made out or not. ठीक है. Then the court discharges the accused if there is no prima facie case. That means no trial will take place. Else, we go to the framing of charge. And when we go to the framing of charge, there are several proceedings that take place during the framing of charge itself. In the framing of charge itself, we will have plea of guilt. Do you remember? Charge proceedings में था. There will be first arguments on charge, then framing of charge, then plea of guilt. Now, what is plea of guilt? Plea of guilt is that the court will ask the accused whether you plead guilty or you claim to be tried. क्या आप कहते हो कि आपने ये काम करा है, ये ऑफेंस करा है, या आप कहते हो कि आपको ट्रायल चाहिए? अगर आपने ऑफेंस करा है तो दैट मीन्स यू आर प्लीडिंग गिल्टी, दैट मीन्स वी शुड कन्विक्ट यू, आप खुद ही मान रहे हो आपने करा है. And if you are not pleading guilty and you say that you want to be tried, that means we will conduct your trial. So now the court will take a plea of guilt from the accused. That let us ask you, and they have written, shall record the plea and may convict. Shall record matlab it is mandatory for you to record. Whatever the accused says, that I plead guilty or I claim to be tried or I don't plead guilty, whatever the accused is saying, you are supposed to record it. But if the accused pleads guilty, it is your discretion to convict the accused or not. Meaning to say what? There might be a father trying to save a son, a subordinate trying to save the superior, a gang member trying to save the members of the other gang. Since it is an extremely grave offense because it is triable by the court of session, the court has to be very, very cautious in examining the plea of the accused. And even if the accused says that I plead guilty, it is your discretion whether you want to convict the accused or not. It is your discretion whether you want to convict the accused or not. It is not mandatory for you to convict the accused even on the basis of a guilty plea. समझ आया? समझ आ रहा है? Yes or no? Okay. Then you frame the charge. And at the time of framing of charge only, you might encounter a situation where you might think that this case is not exclusively triable by the court of session. Then also what you will do is you might frame a charge. You might frame a charge and send the case to the magistrate for trial, that this is not exclusively triable by me, although I am framing a charge and sending it to you for trial. Or you might send the case without framing the charge, that you please conduct the trial by framing the charge. It is not exclusively triable by me. But if it is exclusively triable by you, you frame the charge, and the next step is you fix the date for prosecution evidence, because the primary burden of proof is on the prosecution. And the prosecution has to prove the case against the accused beyond reasonable doubt. So the first burden of proof that has to be discharged is that of the prosecution. The prosecution has to prove that yes, this accused has committed the crime. So you will first fix the date for prosecution evidence. Once you fix the date for prosecution evidence, after that, the next step is issue of process. Whatever witnesses are to be called, whoever person is required by the prosecution, you will issue summons to those people. And after that, there will be a stage where the date comes and we will start with the prosecution. That means the prosecution will now present all the facts available against the accused. भाई accused ने ये करा है, ये fact है, ये करा है, ये fact है, ये करा है, ये fact है, सबकी evidences देंगे. Prosecution अपने witnesses का examination in chief करेंगे, accused अपने witnesses का cross examination करेंगे. So there will be examination in chief and cross examination from both sides that will happen. And the prosecution will try to establish that the accused is guilty. Sessions trial is the only trial where there is acquittal twice. Since it is a very, very grave offense, please listen to me very carefully. Since it is a very, very grave offense because it is exclusively triable by court of session, हमने ये कहा है कि prosecution evidence होने के बाद अगर court of session को ये लगता है कि prosecution ने अपना केस reasonably justify या establish नहीं करा, that means prosecution ने अपना burden of proof discharge ही नहीं करा ढंग से, that means prosecution has not been able to establish its case. हम डिफेंस को क्या सुने, हमें prosecution की बात ही लूज लग रही है इतनी, हमें यही लग रहा है कि जो prosecution बोल रहा है बेकार है, हमें यही साफ साफ लग रहा है कि जो prosecution कह रहा है उसके बेसिस पे हम कन्विक्शन के लिए आगे भी नहीं बढ़ सकते. तो we will do an acquittal. Why acquittal? Because we have already framed the charge. तो प्रोसिक्यूशन की बात सुन के अगर हम कन्विंस नहीं हो रहे हैं ना प्रोसिक्यूशन की स्टोरी पे, तो वी विल ग्रांट अक्विटल। और अगर अक्विटल नहीं हो रहा है तो द नेक्स्ट स्टेप आफ्टर प्रोसिक्यूशन एविडेंस एंड बिफोर डिफेंस एविडेंस, द नेक्स्ट स्टेप इज वी विल टॉक टू द अक्यूज्ड। हम पहले अक्यूज से बात करेंगे, यहां पर मैंडेटरी है अक्यूज से बात करना, सेक्शन 351। वी विल टॉक टू द अक्यूज्ड। भाई बताओ तुम्हारे खिलाफ यही एविडेंसेस हैं, क्या कहना चाहते हो इस बारे में? डू यू वांट टू से समथिंग ऑन योर बिहाफ? क्योंकि आपके एडवोकेट तो आपका केस लड़ेंगे ही, पर आपके मन में क्या है हमें बताओ। दिस इज कॉल्ड डायरेक्ट डायलॉग बिटवीन द कोर्ट एंड द अक्यूज्ड, 351। डायरेक्ट डायलॉग बिटवीन द कोर्ट एंड द अक्यूज्ड। ये हम एविडेंस में बहुत डिटेल में पढ़ते हैं, इन ग्रेट डिटेल्स वी रीड दिस इन एविडेंस। हाँ, 313 CRPC, वेरी गुड, राजस्थान में दोनों आ रहे हैं, याद करते रहो। 313 CRPC, 351 BNSS is 313 CRPC and 348 BNSS is 311 CRPC। ठीक है, सो हम अक्यूज से बात करते हैं कि भाई तुम्हारे खिलाफ यही एविडेंसेस हैं, क्या कहना चाहते हो? कुछ कहना है, कुछ लगता है अपने फेवर में कहना, क्योंकि आपके एडवोकेट तो आपका केस प्लीड करेंगे, बट यू हैव समथिंग टू से। So that is 351, direct dialogue between the court and the accused. After this is done, we start with the defense evidence. We fix the date that on this date we are going to start with the defense evidence, and the defense counsel may require some summons to be issued, but please issue some summons to these witnesses and call them on this date, etc., etc., according to their convenience and schedule. Now one day will come when the defense evidence will start. Now defense will try to disprove and demolish the entire case of the prosecution and create doubt in the mind of the court, because accused need not prove his innocence beyond reasonable doubt. Rather, the prosecution has to prove the guilt of the accused beyond reasonable doubt, and the accused only has to create a reasonable doubt in the mind of the court that this person might not be guilty. So then you will lead defense evidence, where you are going to try to disprove each and every fact which has been proved or tried to be proved by the prosecution. After the defense evidence, we will ultimately reserve the case for judgment, and we will reach a situation where we will pass a judgment of acquittal or conviction. If a judgment of acquittal is passed, well and good, please go home. If a judgment of conviction is passed, then we will postpone the case for sentence hearing. We will then hear arguments on sentence कि कितनी punishment मिलनी चाहिए, probation पे छोड़ना चाहिए, admonition के बाद छोड़ना चाहिए, कितनी punishment दे, किस type की punishment दे, कितना fine हो, payroll का क्या, etc., etc. बहुत सारी चीजों के बारे में फिर चर्चा होनी शुरू हो जाती है. That is the judgment on conviction and sentence hearing. So first what happens?